Hello. For those of you that don't know me, my name is Ira Smith, President of Ira Smith Trustee and Receiver Inc. And yes, I do look different than the pictures of me on our website. I want to make this video to describe some very exciting news. I've made some notes, so you will see me looking down from time to time. In our Brandon's blogs, Brandon has written several blogs on what happens when there's a deceased estate that is insolvent. As a matter of fact, one of our most popular blogs ever is his blog, What Happens to Debt When You Die Canada? Are You Free of Debt? He has also written on estate matters, not from an insolvency perspective, but on topics such as probate in Ontario, the skill set needed to be an estate trustee, and why a licensed insolvency trustee, such as ourselves, does possess the skills in acting as an estate trustee. Historically, estate trustees have been either trust companies, lawyers, or relatives, close friends of the deceased. Based on our work with insolvent deceased estates, we have learned all about the emotions and even pain that family and business ties and squabbles can cause in estate matters. So I am pleased to announce that on July 17, 2019, we have opened up a new business division called Smith Estate Trustee Ontario. Down below, you can click on the button that will take you to our new website dedicated to that new business. Check it out. Let us know what you think. We are interested in your comments. Why would you use a licensed insolvency trustee to act as an estate trustee? Well, we have the skill set to perform the role, and we are known by the courts already. We understand the statutes that are involved in administering a deceased estate. There are problems that we can solve for the beneficiaries, for the stakeholders, and for their professional advisors. In Ontario, an estate trustee is the only person with the lawful authority to look after the administration of a deceased estate. Probate is a process to ask the court to either give a specific person authority to work as the estate trustee or to verify the authority of the person named in a will to act as an estate trustee. Sometimes it's just necessary to have an objective and experienced third party assigned to function as the estate trustee. Think about the following circumstances and the problems that might exist. Moms and dads want to show their children how much they love them, so they appoint them all as estate trustees. Not every child has the same abilities, interests, and skills. Not every child wants to function as an estate trustee. If none of the children want to, or squabbles and fights arise because the children who aren't as skilled as the others don't think things are being done right, it may just be a situation where a neutral third party should be inserted to be the estate trustee to resolve all the issues, monetize the assets, and distribute them to the beneficiaries. Lots of well-off families have disagreements of just how the family's riches should be divided up. Well-off families are not above taking these private fights and making them public through the courts. A lot of money, time, and energy is spent on fighting, but not on protecting the assets, monetizing, and distributing them. This is where an independent third party can come in to protect the estate while the family members keep fighting. Perhaps someone passes away who has assets but no will. Many people may come forward claiming to have an interest in the assets. An independent third party would be very helpful to sort out all the potential claims, come up with the real claims, protect the assets, monetize them, create a potential frame for distributing the assets, the cash that's generated from the sale of the assets, and then getting court approval to actually distribute them. Perhaps you are a lawyer or financial advisor to a great client who has recently passed away. That great client was the driving force behind a business that has produced many, many, many good billings for your firm. Reluctantly, you had agreed to be the estate trustee because you were the only person that that client trusted. Now you find yourself in the middle of a squabble amongst all the beneficiaries. You find yourself in a conflict. The conflict is so great that if you cannot resign as the estate trustee, you may very well lose that great corporate client and all of its billings in the future because of the disputes in the deceased's estate. Wouldn't you love to be able to punt to an experienced, neutral third party who you know will do a good job and get you out of the trouble, the conflict that you find yourself in, so that you don't have a conflict in continuing to advise your great corporate client? As a lawyer or financial advisor, of course, acting as the estate trustee is not a problem. Nevertheless, perhaps the time required may just take you away from your professional practice to the point where what you aren't keeping your eye on is greater than what you'll get from being the estate trustee. Another situation where you may want to have a neutral third party take your place. The person named as the estate trustee has a true conflict and will not be acting impartially. That is a situation to replace them and insert a neutral third party like us. There is crucial demand for a estate trustee during litigation, like the example of the rich family members that I mentioned previously. We can fulfill that role. Our experience in working as an officer of the court has actually resulted in our being identified for acting in a proficient and neutral fashion. We understand exactly how to navigate the statutes and the courts. We can find cost-effective solutions that everyone will be happy with. Our mix of empathy, experience, and impartiality provides us with a distinct viewpoint and the capability to appropriately administer an estate, minimize the problems, and accomplish outcomes for all stakeholders in an economical way. So we are a professional and impartial officer of the court. We can be a estate trustee under litigation. We can resolve conflicts, protect and monetize assets, come up with a distribution plan, and then distribute the money. And of course, where there's insolvent estates, we can act as trustee in bankruptcy of the insolvent estate. We provide a full range of services for complex estate issues to end the pain and frustration of the stakeholders and their professional advisors. We apply our expertise and creative thinking to take care of all details to end the pain for the beneficiaries. So contact Smith Estate Trustee Ontario for a free consultation. We are very excited to provide this new business, this new service, and please click on the link below and check out our new website and let us know what you think.